All right, I think we're ready to go.
Showtime.
Welcome. Thanks for everyone coming to this session. This is our highlighted research panel, our research competition that we've done now. I think this is the 4th year. And we have 4 great papers, 4 great studies from esteemed authors and scholars who will impart this wisdom that they gained with the hope that it'll help us better understand the FOIA landscape and maybe do something about it. So the goal here is to apply research to reality, to be able to provide insights that everyday people could use, coalition directors could use, lawyers, journalists. That's the goal here. So we're going, hold. Oh, okay, we haven't started yet. Oh, great. Now I have to remember what I just, now we're live. Hello, everybody. I'm Dave Coulier, your game show host today from the University of Arizona. We're starting to cool down. And thank you for showing up for this session on our FOI research competition papers. We have 4 great studies for you today. And the authors here, they're going to each talk through it, and then we'll talk at the end with Q&A and discussion. So during this session, feel free to put comments in the Zoom chat, and I'll monitor that. And then at the end, after the presentations, we'll engage. The idea here is to take this scholarly egghead research and make it relevant to life, make it relevant and useful to coalition directors, lawyers, journalists, citizen activists, everybody who cares about access and making it better. So that's going to be the focus of this. We want to keep it real. So I'm going to let each of the authors and sometimes co-authors introduce themselves, and we'll start with a paper. Well, I love all these papers, but this is a paper that I'm particularly fond of because it looks at home addresses and access to home addresses, which is becoming more and more of an issue in legislatures and in our society, with privacy being all important. So let's start with that paper. With we have 2 authors here, Jody Gill and Robert Smith. And and I'm sorry, Kauthar Badr. All 3, I'm so bad, sorry. All from Southern Connecticut State University, is that correct?
Correct.
All right, got that right. From Hartford, is it?
We're in New Haven, Connecticut.
Oh, you're in New Haven. I was just there. That's so cool.
It's a great
so
city.
Pretty there. All right. Okay, onward. Take it away, folks.
So do you want us to just go through introductions for everyone first, or would you like us to go through the paper?
Yeah, why don't you introduce each of yourselves and then go through the findings.
Sure. So I'm Jody Gill, an associate professor of journalism here at Southern Connecticut State University. I'm a former daily news reporter and turned academic. I've been teaching now for the last 10 years and still reporting on the side. Active member of SPJ in our state and now advisor to our student chapter for SPJ. So I'll let Rob and Kauthar introduce themselves.
Hi, good afternoon, everybody. I'm Rob Smith. I'm an attorney. I have been admitted to the Connecticut Bar for 17 years, and I've been a member of the federal bar. I don't even remember, maybe about 5. I've been practicing for all 17 of those years and teaching for 12 of those years. I'm an associate professor of business law here at Southern. And I also have the privilege of teaching in Jody's department, media law and ethics, to our journalism students. So very excited to be here and have this discussion with you all.
Hi, everybody. My name is Kauthar Badr. I am an associate professor of business law in the same department as Rob in the School of Business. I'm also an attorney duly licensed to practice in this state, and I have practiced for many years. I still practice. And I'm also a research attorney for LexisNexis. So I do a ton of legal research And this is right up my alley because privacy is incorporated into a lot of the research that I do and a lot of the scholarship that I produce. So I'm excited to be here amongst all of you all and at a conference where we are going to keep it completely real. That's right up my alley. So.
So I'll share my screen, and we've got just a couple slides just as we kind of go through everything. Are you able to see what I'm showing? Okay. So I've been looking at FOI privacy exemptions for the last several years, and kind of zeroed in on home addresses as something that surprised me as becoming more private, more closed off in state laws. And so I teamed up with Rob and Kauthar this summer, and we just really dove deep into each state's FOI law to try to get a broad understanding of how do different states approach release of home addresses for non-disclosure. We see it as a proxy, for privacy concerns, and a really interesting one because it used to be considered pretty public and open, and that's kind of shifting. Attitudes are shifting. So we saw that as an interesting point to look at in these laws. And there's been a lot of examples of harassment, threats, violence against several people, including judges. And so we've definitely seen this as a point of tension, and we wanted to explore that more. So we looked at every state's law, and we also used other resources like the Reporters Committee for the Open Government Guide from the Reporters Committee for Freedom of the Press. And we also looked at if an attorney general or a state FOI group had published a citizen's guide or any sort of case law summary. We used those resources as well to sort of build a robust summary for each state, and then pulled out sort of the highlights and looked at what are some of the trends that we're seeing in the states. And so we were just curious to see what those trends were. I know Rob's going to sort of talk about one part, and then I'll come back and talk about some of the individual exemptions.
Great. So what we found when we look through most of these states have, we found many of them exempt some home addresses in certain categories, or they allow for the exemption based on privacy grounds and employ some type of balancing test when trying to determine what would be allowable to be disclosed or what should be kept private. For example, New Hampshire has a balancing test like this, and it will exempt records that where the disclosure could constitute what they indicate in their law as an invasion of privacy. And they have a 3-part test written right into their law. Is there a privacy interest at stake? This is the first prong of the test. Is there a privacy interest at stake that the disclosure would invade or exploit? Second prong, would disclosure inform the public about conduct and activities of its government? And in trying to make the decision as to whether something is disclosable, they would reckon with balancing the public interest in the disclosure about the conduct and activities of certain people in government. So, or in other areas that are spoken to in the legislature. For example, when a judge is the subject of, or another public safety officer or somebody else is the subject of an issue that's being probed, is there a home address really all that relevant to the situation? And that's what they're trying to balance. Kentucky is also another state that doesn't mention home addresses, but has exemptions for public records containing information as how they define as of a personal nature, where the public disclosure of would constitute a clearly unwarranted invasion of privacy. And this language in the Kentucky statute actually very closely mirrors the federal FOIA Act. Further, Alabama is another state that doesn't mention home addresses, but does have a reference to an exemption for records relating to or having an impact upon the security or safety of persons, structures, facilities, and other infrastructures. And the state further opines, or the law further indicates that the public disclosure of which could reasonably determine or could reasonably detriment the public safety or welfare. So as we can see, even states that don't have specific protections for home addresses do broadly refer to these types of things in their statutes. And we found that in a good number of states. So next, I'm going to go back to Jody.
So yeah, even the states that do list home addresses, it seems like more often are now identifying specific people who are protected from this disclosure. And that was something that really interested us, and we tried to dive deeper into. It's a little hard to get every single person who's exempted, because sometimes the court cases will weigh in a different way than what the statute says. But generally speaking, the individuals who are exempt from disclosure are public safety officers, judges, court employees, people who tend to have some sort of power over others, especially as it deals with their freedom, with other people's freedom. And that's the kind of cases where you certainly see examples of someone maybe trying to threaten or harm police officers or a judge. And so there's certainly cases where people have found these individuals at their homes and tried to either threaten them or cause them harm. Certainly in New Jersey is the case that started Daniel's Law, that's really talked about across the country now, and it's being pitched as a federal law as well. But recently after COVID, we also saw public health employees be added to these exemptions as public health officials were being harassed or threatened with concerns and sort of the conflicts around COVID. So we saw Colorado, California, New Jersey, they all have some sort of exemption for public health employees. And that also includes people working at women's health clinics or places that might provide abortion care. So that is something that we saw before, but we saw an increase of that during COVID. And then there's also individuals who can ask to get their name withdrawn from records. And some states actually allow anybody who has a safety concern to ask and request that their information is withheld from voter records. Arkansas, Hawaii, Idaho, Missouri, Nevada, Utah, they all have some provision that allows individual citizens to ask for that to be withheld. And then there's also several states that look at not the people in power, but sort of the average person, and they allow exemptions for those people whose information ends up on government documents, but they're not necessarily in the public eye. So folks who are enrolling in public programs, minors in particular, in recreation programs. We also saw some where people were allowed to withhold information from like ride sharing apps and that sort of thing. So if there was some government entity that's tracking addresses, some states, Indiana stands out as one, as I recall, that allow people who are sort of average people to withhold their names. And Cowther's going to talk a little bit more about the address confidentiality programs that exist sort of in many states.
Yeah, so we also found that jurisdictions oftentimes carved out address confidentiality programs that allowed individuals, certain at-risk individuals like victims of crimes, sexual crimes, particularly domestic abuse victims, and also some high-risk employees like those healthcare officials that Jody was talking about, or judges like Rob was talking about, to actually apply to have their home addresses exempted from public disclosure. So we found it interesting because so many jurisdictions are moving towards having those kinds of programs, particularly the ones that seem to have more narrow exemptions for non-disclosure of the home address. So we found it was interesting that in those jurisdictions that seemed very broad and open for disclosure, they started to carve out these exemptions or the ability for folks to get their addresses to not be disclosed by applying to these kinds of special programs. So Jody, back to you, I think.
Sure. There's also other ways that states are sort of handling the concerns regarding release of home addresses. So some have penalties for release. California, Colorado, Arizona, where Dave is located, all have some sort of penalty worked in, where if you were to publish, a judge's address, you could actually be fined or be held liable for that. And then there's also a couple states that have greater access for journalists. So while they might close off home address records with home addresses, they would allow a journalist, for example, in Colorado, can call and fact check with the agency. I'd like to find out more about how that works. And then Ohio actually has different rules for journalists, like they're exempted from these exemptions. And so some key takeaways, if my screen lets me do it. Essentially, we found these exemptions exist. They're pretty widespread, and they are being added with more frequency as people become more concerned. But we've also found that in the literature that we've read so far, it's oftentimes complicated and confusing for the records holders. So there are states where it's happening that we're seeing exemptions written into law, and records holders are confused and withholding more than they should be under the law. So there's some excess withholding happening as a result of confusion or just complication. We're also seeing that, these address replacement programs could be some avenue to help records holders not have that confusing sort of exemption, because they give a replacement address rather than just having pieces of the documents redacted or entire documents withheld. And so that's an avenue possibly to help records holders not have a complicated process. But we kind of came down on it. It was really hard for us to make a recommendation because we are advocates of transparency, but we kind of came down on balancing tests maybe being the best sort of middle ground approach, because they certainly take it on a case-by-case basis and might address some of the concerns and still allow for releasing information where it's needed. But we do acknowledge that that can certainly cause delays and is sort of susceptible to possible bias, right? Who's making that decision and what's their opinion on that? So those are our sort of takeaways, and we're really looking forward to answering questions and, having a discussion about it further.
Thank you so much. Awesome stuff and great questions already coming into the chat. Looking forward to discussion later. All right, next paper up. Let's go to COVID. We're not sick of COVID yet, are we? No, it's still, I think it's still around. So let's go to COVID-19 and North Carolina jails building a database. Take it away, Felicia.
Thank you, David. And I think it depends on who you ask, right? Wasn't there a presidential commentary about it? But hi, everyone. My name is Felicia Arriaga. I'm an assistant professor of sociology at Appalachian State University out in Western North Carolina, or at least for a few more months. My paper and some of the presentation I'll be giving is on COVID-19 in jails in North Carolina. I actually came to this conference, a friend suggested that I submit for this, who works in American Oversight. And I was like, oh, yay, an opportunity to talk about public records. Let's do it. So excited to be here. I don't get to do this that often, so I'm excited about that. I also just wanted to start in the paper. I included a few images from the Nash News, which is actually a prison pamphlet that is produced by prisoners within the Nash Correctional Facility, which is actually a prison in North Carolina, but wanted to bring some of that in to this space, partially because I think one of the implications, at least, I'm a community-based researcher, not a journalist, but one of the things that I think the research that I do and our research team is really committed to is really being transparent and bringing out the need for more transparent information regarding the carceral state in general. So after we had done one of these interviews with our NPR station, actually, one of the folks who was incarcerated actually sent us this mail and said, hey, we listened to you. Thank you for doing this, right? So as far as like the motivation for why I continue to do this work, that's partially it, is making sure that we're trying to at least give some of that context for people who are experiencing it on a regular basis. So again, a lot of the research, we were able to partner with some journalists to get some of the research out. But some of this was also meant really for organizers who were working in local communities to be able to actually have an understanding and grasp of what was going on in the jails. They were often being contacted by people who were incarcerated, sometimes loved ones, sometimes family members, about some of the conditions. And so this is part of that effort. Every year, there's something that's called the Vigil for Freedom and Racial Justice, which focuses on trying to get folks out of local jails and prisons across the state. Since we focus on jails, I hope most people on this know that jails are run by sheriff's offices, at least in North Carolina. And so this is some of the political education work that I do in sort of like my organizing time, but also use this in the classroom setting to be able to help people understand what are some of the roles of at least this part of the carceral state. Again, some of the impetus for doing this was also focusing on thinking about mass incarceration as a public health issue. One of the co-PIs on this project is at UNC Chapel Hill in the public health school. And so a lot of the sort of messaging that we were getting, especially from the CDC and from other sort of entities, were obviously telling us to do a lot of these things here, right? So isolating all of those things, especially at the beginning of the pandemic. But as you all can imagine, those are going to be impossible for folks who are incarcerated. So that was one issue. In the paper, and here I just included a little bit of the timeline. I have way too many slides for this, so sorry about that. But we also just wanted to track too, over time, what was the actual sort of policies that were coming down from different entities, and how then were each sheriff in North Carolina actually interpreting those to implement different things within each local jail. Some of you, if you work in this area, also probably know that getting a full sort of accounting of the number of people in jails, any of the conditions, some of those things is also just hard and challenging. Also one of the reasons that we started this project, but also some of the other projects that our team works on is just trying to get more data transparency in general. And so again, at least when it comes to COVID-19, a lot more sort of, I think, not government agencies, right, who were taking on some of these efforts to get some of this information out. So we definitely sort of are following that line of thinking and trying to get this information out to journalists, but also to the community members who might have the ability to make some local impacts too. We did 3 rounds of data collection for this. And if you've read the paper, you have more sort of specifics there. And this is across about a 2-year time period. Right, and then our last round, the 3rd round, included some questions about vaccinations as we saw some of that start to ramp up and more emphasis for that to happen in these areas too. We sort of grouped some of our findings into a few different areas. One is sort of like broadly the decarceration efforts, which at least for some of the community-based organizations that are working on criminal justice reform policies, this was also an opportunity for them to make sort of a narrative intervention around the possibilities of what can happen. And so we grouped these efforts into sort of changes with patrol, specifically for police and sheriff offices. So one sort of clear example of this would be giving people citations instead of actually taking them to jail, right? So that would be a decarceration, or at least like a decrease in the population coming in. We had some sort of specifics around incarceration, so early releases were also some sort of examples of this that were happening based on different criterias. And I think one of the sort of sheriff responses to our questions about this is maybe one I think a little hopeful as far as the way they're thinking about it, but was not consistent across sort of the different agencies. So in Vance County, the response was, it's not a fair statement to say that we got the numbers down to prevent the spread of COVID-19, but to ensure that the constitutional rights of those being housed pre-trial are upheld. That was the only one of all of the agencies that ever said anything about sort of the rights of those incarcerated. We have a few graphs just across sort of the 3 rounds that we collected information from. And this is just the jail population numbers. Again, I think some of you responded to the poll question of it, how many of you knew the number of people who had COVID-19 in your local jail. Well, even being able to know how many people are in your local jail on a regular basis is the number that, at least in North Carolina, is not tracked in one central location. So this is also, again, creating the database and being able to help people understand this is what maybe the average population looks like across time. And we saw a lot of sort of emphasis on trying to move people out of local jails at the beginning of the pandemic because of some of these state guidance around that. But as we went through sort of the end of 2020 into early 2021, the numbers actually picked back up, right? So if there was an intervention to actually change the population amounts, it actually shifted at the beginning, but continued to sort of the normal amounts before. This is just a snapshot of today. The North Carolina Department of Health and Human Services does track and tracks every Tuesday and Friday, updates these numbers on the number of staff and what they call residents who have COVID-19. And so this is at least one part of the picture, but this is all that was being posted and updated. And you can see here that there are still large numbers, right? And so part of our questions were also, how were the jails and the sheriff's office employees, how are they going about actually trying to contain some of the spread of COVID-19 as well? And there was some guidance from at the state level from what is called this local confinement facilities guidance that they were given. But some of that itself did not necessarily sort of push for full out testing. So this was still sort of only testing symptomatic staff and detainees in close contacts. And so that was pretty consistent across the rounds that we did. And then I think the one sort of issue that really a lot of community organizations pushed back on was this lack of staff testing, especially because if you can imagine, staff are the ones who are actually bringing in COVID into the facilities. It's not necessarily the folks who are rotating in and out. Again, just a little bit more information here about sort of staff vaccinations. And a lot of this was that actually the agencies weren't tracking in the first place the number of vaccinations that were being distributed. So not a great accurate picture of these things, but more than what we have at different sort of agencies at the state level. And I'm just gonna skip ahead. And again, just to reiterate this point, that there was a few studies that were done in the prison system to look at vaccination rates among those who are incarcerated. And those studies were finding that the people who were incarcerated were much more likely to take vaccinations. And there were some incentives, at least at the state level in the prison system, for those to happen. In the jail system, we only found one instance where there was some kind of incentive given to folks who are incarcerated to actually get vaccinations. I'm going to stop there. A few conclusions here, but excited to have more conversations about this as well.
All right. Thank you, Felicia. That's awesome. That's great. So let's turn to, so since we're talking kind of law enforcement and stuff, let's move to owning the police, crime, copyright, and public information with our good friend, AJ Wagner from Marquette University. Take it away, AJ.
First of all, thank you to our host, and thank you for everybody attending and participating. Erica for running the slideshows the last 2 days, because I don't trust myself to do it. So thank you guys. This will be very brief. This is a fairly narrow interest that I have, that I came across an instance where I was just kind of blown away that this existed. And then I just kind of went down the rabbit hole, and this paper is the resulting product of that. And I'll just start with the anecdote that got me interested and kind of walk through some of the pieces. But in 2010, Public Engines, a company that publishes online crime maps, filed a lawsuit against Reportsy, another online crime mapping company. Both commercial companies relied on maps that plotted law enforcement data. So details on incidents or calls for service. Public Engine's lawsuit included claims that Reportsy had committed computer fraud, breach of contract, hot news misappropriation, violated the Lanham Act, and the Utah Anti-Cyber Terrorism Act. Very similar sites, these two. If you looked at them, you probably wouldn't notice a lot of difference. And again, they are mapping crime data. You've likely come across something like this before, maybe not, but a pretty common site, I think, on the internet. And they don't look all that different, but they were very different under the hood. Public engines made their money and got their data by providing databases for law enforcement. And then they would use those databases to publish those crime maps. And often they would sell it to them. Sometimes they give it to them for free. It varies by the company. And then Reportsy did it all on their own. Some of them were FOI requests. Some of them they got public feeds in different ways. And some of them they scraped. But after they Reportsy couldn't get information from different law enforcement entities across the country, they started scraping. But they would go back to these law enforcement entities and say, you're giving them to public engines. Why won't you give this information to us? And they would say, this is our official crime data provider. What they do with it is up to them. So the police won't give the information to anything other than their official provider. They don't feel like they need to provide the same data to other entities. So we see this over and over again. Reportsy actually walks away because they don't know that they can win the court case. So they just walk away and stop scraping and just move on and continue their opportunistic collection elsewhere. 12 years later, this practice still exists. In many instances, governments give exclusive or preferred access to government information to corporations. There's other instances of this. Same-day court access or court document access. We've seen this happen in 3 different states. Georgia's official state laws were subject to an ownership dispute due to LexisNexis claiming ownership over annotations. If anybody follows that one too closely, that's the Georgia v. Public Resources, the Carl Malmood case that was determined by the Supreme Court in 2020. And then government building ordinances are often farmed out and made usable by trade organizations for a profit as well. And Erica has put the slide up for me, and you can see the companies that kind of dominate this space. So I went and looked at the 250 largest cities in the country and looked at how many of them had these crime maps and what these crime maps looked like. And then I went through and looked at what the contracts looked like, what the terms of agreement looked like for these different places. And you can see LexisNexis has a large share of the market. There's a couple smaller ones, notably Motorola, City Protect. They bought one of the big ones and then actually divested from the market. The ones that they do have are terrible. It's just falling apart. They've clearly quit the market. But then there's another interesting piece is the in-house ones as well. And I thought that those are interesting and worth looking at themselves. One that really stuck out was Philadelphia has a really cool one, really powerful, really well done, a little bit laggy, but graphically really cool. But these all typically use Esri's ArcGIS, which is generally considered to be an open platform. So if you see open house or in-house, these are ones are generally where you can have the crime data as well. The other ones, some of them will provide tabulated data or tables of the crime data, but they'll intentionally degrade the usability of it or make it difficult to use. So that's a new development. A few years ago, they didn't provide the data at all. Now they'll put it online, but they won't let you download it. They won't let you copy paste it. They're intentionally trying to hold on to the data. And they use different legal methods for holding on to this stuff, terms of use, breach of contract, copyright stuff. They resist scraping through dated hacking laws, though this has probably been cleaned up in the last couple of years. I won't belabor the legal landscape here because there are some kind of shifting and some reason to believe that with more pushback, the crime data may be available to all. And there was actually a really good positive Pennsylvania OOR decision this week regarding access to York, Pennsylvania's information. But again, now I'll get into the solutions. But again, the big picture problem here is that they're offering this information for corporations. Often they set up an API and they'll give it to a preferred corporation or interest and then deny it for everybody else. And the way that I'm kind of thinking through this, and I think some of these are more interesting and others more possible than others, but particular barring the sharing of crime data with commercial entities. Will this ever happen? It's probably unlikely, but it's within the realm of possibilities. I don't know that there would probably be some downstream negative consequences of something like that. But when you think about entities that should have or should be able to use or profit off of crime data, I would put commercial entities somewhere near the bottom of that list. Establishing a statutory right to crime data. If you make it clear that crime data is subject to FOI laws, there is no ambiguity, there's no uncertainty about whether this information is for the public or not. There is no dithering, there is no saying this is the official provider. It is just, would just be ours. It would be open and shut. And this idea of creating parallel access, I think this is a great idea. I think it's pretty practicable, but the idea that if you're going to share something with a commercial entity, it also needs to be made public. This seems like a very easy to apply, very common sense principle that maybe we could continue to think about how we could apply across the board, whether it's crime data or something else. But it only makes sense to me if you're going to share something with a commercial entity, it should be shared with the public as well. And again, this kind of fits into how we start thinking through what affirmative disclosure looks like and whether we are going to actually start embracing the internet and embracing all the digital possibilities that are out there. And then the last one is realizing a generalized right of access, something along the lines of a constitutional right to know. This is pie in the sky stuff. But again, the idea is making it very clear that when there's ambiguity, the information belongs to the public. And again, the more nudges we can have, the more effort, or the more places where we can suggest that the information belongs to the public. And then when there's uncertainty for a custodian or a judge, they'll look to whatever that nudge might be, whether it's a generalized right of access or whatever it may be. Again, more nudges, the better. And in instances like this, where there's uncertainty about whether the crime data is a public record or belongs to the public, this would hopefully provide a little bit of guidance. So that's all I have. And I look forward to discussing it more with folks. Thank you.
Thank you, Dr. Wagner. Appreciate that. Last paper of the day, but not least, of course, Dr. Stewart, co-authored with Dr. Amy Kristen Sanders and Stephen Molchanov. I'll let you take it away, Chip. With this paper, is it just dumb luck? The challenge of getting access to public records related to smart city technology.
All right. Thanks, Dave. So I'm Chip Stewart. I'm a professor at Texas Christian University in Fort Worth. A lot of my research over the years has been FOI, open records, open meetings, going back to my master's thesis and dissertations at the University of Missouri several years ago. My co-author on this one, actually the lead author, is Dr. Amy Kristen Sanders at the University of Texas. We've collaborated on some pieces on FOIA and public records over the last few years, and her graduate student, Stephen Molchanov at University of Texas. And the idea on this one was, like some of the research I've done and that Dr. Sanders has done over the years, is trying to look forward a bit at some of the challenges that are just now coming up and more likely to be around a lot in future years when it comes to the kinds of records that are being collected and generated and potentially released on us and with some new technologies. This one, when we talk about smart cities technology, we're really dealing with all of these different types of technologies that are embedded in cities, either government owned or third party owned, but on contract with the government, basically to engage in widespread data gathering, surveillance, that sort of thing, usually with some sort of public interest regulation or law enforcement in mind. One of the examples that inspired this was the Lens in New Orleans was seeking access to records on some of the smart city tech that New Orleans had employed. This was specifically some license plate readers, so automated license plate readers, facial recognition technology, police surveillance, body cams, those kinds of things. They'd asked for access to this data and were basically thwarted under Louisiana's open records laws. And they realized some of the challenge here, which is that local governments are amassing all kinds of data and information about us. And while we obviously have a privacy interest in them not just releasing this information fully out to the public all the time, we also are losing a lot of opportunities for oversight of how that data is kept and what is being done to secure data privacy and security for the people on who it's gathered. Another one, so my role in this paper as second author, I was mostly doing a lot of the background and conceptual ideas on it, was one that came up in the literature a lot was the Toronto waterfront, which was a partnership with Google. That similarly gathered a lot of information. And then basically the Toronto, part of the deal they had with the city of Toronto was to exempt a lot of that from disclosure under open records laws. Some of these kind of private third-party vendor agreements where the local government says we'll defend you against all open records requests and agree not to give things out, which is work that Dr. Sanders and I had done before on private vendors. So what we wanted to look at is how are state laws designed to handle some of the particular challenges here with smart city technologies. Again, the types of records we're looking at, the types of technologies we're looking at, and the records they generate would be things like streetlight cameras, public transit monitors, water systems, electric grids, monitoring systems for those sorts of things. Microphones, public microphones such as ShotSpotter, which I don't know if you're familiar with this. This picks up gunshots and reports them. Of course, these were seen to very heavily over police minority residential areas. Mobile apps that cities themselves generate or some of these smart cities generate. And of course, the private third-party vendors of these would be like Uber, Lyft, some of the apps they have and the information they gather, which is sometimes in some sort of partnership with the city. Ring cameras, so the front porch cameras, which are often also on some sort of contract, or at least Ring is via the terms of service with local police and authorities and law enforcement. First thing we did was we looked at the definition of records, how different states are defining records to see how these types of records might classify. Like many states, there's kind of a broad range of definitions here, from your very narrow kind of print generated, print based types of records that are very much, again, thought of or created back in the 50s and 60s when these laws were created, kind of a print first mindset. But other laws, and most laws, seem to shift more toward a broader definition of any format in which a government can keep a record. And that would be things like Texas and Florida, that if the government stores it, it's a record. Doesn't mean you automatically get it, but at least it falls under the open records law. Then we look at 3 particular exemptions that are challenging and that cities or local governments are using to deny access to these. Trade secrets involving third-party vendors is one of those, of course, which again, Dr. Sanders and I have written about in the past. Basically saying that the information gathered here and the technology used and the method by which it is gathered are exempt under open records laws because they're proprietary trade secrets and could put the companies who gather them at a competitive disadvantage. Of course, this could really thwart efforts at oversight and potential abuse on AI and facial recognition technology, that sort of thing. Another is, of course, law enforcement exemptions, ranging again very much from very narrow to very broad. Of course, if we look at law enforcement exemptions that are much that are along the lines of, say, the federal FOIA or other states, which are more like if a record is might jeopardize an ongoing investigation or endanger a witness, any of those sorts of things that can be exempt, but not a broad category of all potential investigative records could be included there. But some states do have a pretty broad law enforcement exemption. I believe Nebraska was an example that we found in there. So this could a broad definition of law enforcement record that could be exempt could limit oversight again on a lot of these which are used for law enforcement, again, police body cams, red light cameras, license plate readers, those sorts of things. And of course, the big one, and this is a real legit concern, and the thing we're still kind of working on, and this is how do we balance this with protecting personal privacy? Of course, the statutes have personal privacy exemptions built into them, and these are legitimate concerns. If the government is watching us through third-party ring cameras, closed circuit TVs, and these sorts of things, we don't want all those records going out into or easily accessible by the public, where basically people could just follow us all the time. If we consent to that by saying I agree on Facebook or Google or your iPhone, that's one thing, but just having them easily accessible through open records requests from the government is another that we probably have not consented to. So figuring out this balance between what's going to have a legitimate personal privacy reason the government cannot release those, but still, again, guaranteeing the public ability to provide some oversight of this sort of stuff is really, I think, the challenge here. So that's kind of, as we wrap up the paper, where it's going next is looking at places that might have a better idea of that balance. One scholar or a couple of scholars had the idea of what they call data stewardship, which is a way to balance the legitimate privacy needs with, by placing some burden on the cities not to reveal or not to release these sorts of things that do have personally identifiable or potentially embarrassing private information about people, with the ability to provide transparency and oversight of these technologies from public advocates and that sort of thing. And this is really happening a lot in the facial recognition technology front right now. So that's where the paper will go next. We'll look more at some other state laws and try to come up with some best practices. We're not completely done with this yet and hope to round it into shape. But with the looking at some more state laws and try to, again, develop some best practices in dealing with this balance in privacy and oversight for smart city technologies. That's all I've got.
Thank you, Chip. Great job. So I might add, all these papers were rigorously reviewed in double-blind, peer-reviewed blind process, each read by at least 3 scholars and FOIA experts. So they were vetted and ranked. And by the way, some of you walk away with cash today. I can't hand it to you right now for some reason, but you will be getting it. So the home address paper, number 1, $500. Good job, y'all. Number 2, the dumb luck, Amy and Chip, good job, $300. And by the way, Chip and Amy, I think this is their 3rd year winning some money. You're in the money, and every year you donate it to the Texas Foundation for Open Government Foundation, First Amendment
Foundation, Freedom of Information Foundation of Texas.
Freedom of Information Foundation of Texas.
Good call.
And our Connecticut contingent, I think they're donating their prize money to, what's the cause?
It's called the Support Our Students Fund. It helps students who have emergencies with, needing food or pay their rent or gas for their car, whatever it is.
That's great. And 3rd place, Owning the Police, AJ, $200. And I hope you're keeping that to take your spouse out to Red Lobster. Yes? Oh, you're muted. Sorry.
Bought a new car seat for my daughter.
A car seat for your daughter. Good, good. That's a good use. Keep the kids safe. So anyway, and I encourage anyone who's interested to, and all of you authors, to submit your papers to the Journal of Civic Information. I will put the link in the chat, and there it is. Anybody could submit. You don't even have to be a PhD or JD or MVD or I don't know what else is out there. DVD. We've had people publish great research in here. And so encourage you to do it. It's a journal that is open access. Anybody could access. It would be ironic for us to hide it behind a publisher paywall. It's a great way to get the knowledge out. Megan put in the chat that the papers that we just heard about today are available online at that link. So check them out if you want to read more. So let's go to Q&A. Hopefully we've had people had time to think and cogitate. We could start with panelists. Do you have questions of one another? I know.
First group,
there you are, Chip.
Hi, very interested to see what you can find out on or what you found out on home addresses. That's one that's, I think, bedeviled a lot of us who've done journalism before, of where you have things that are publicly easily accessible, searchable, like addresses on voter registrations or on property records, those sorts of things. And when those that are used for a lot of purposes, primary purposes, and even just secondary fact-checking purposes, then when they go away, make just our job of verification a lot harder as journalists. So I was glad to see you do that. I'd shared in the chat briefly a particular challenge with address confidentiality programs, which is they're not super transparent about them. So it's one way both of, I think, providing a legitimate reason for pulling home addresses out of the public record, which is, again, domestic abuse victims, harassment and stalking victims, that sort of thing. You go through a program. A colleague of mine and I did a project to try to shed some light just on the programs, what they exist for, how they operate, really to call some attention, not to criticize them, but to show people that they're available. And the programs themselves were super secret. We just wanted to ask for an application form and how many people enrolled. And a lot of people said that is private, it's exempt by statute, specifically in the address confidentiality program itself. And they got really touchy even after they shared it. So I had a lot of my students file open records requests with states to get that information. We gave it to my political science professor friend, Dr. Ferris. When she published that in a map, the state attorneys general and others basically ordered her, either asked or demanded that she take the information down, saying that even though they had revealed it under a legitimate open records request, that they didn't reveal it for that purpose, and they thought it jeopardized the program. So, which of course doesn't make any sense on FOIA or First Amendment grounds. But nevertheless, when you've got an AG sending you demand letters to cease and desist publishing things on your website, that's a little chilling. But anyhow, just to give an example of some of the challenges that come up just on one particular program. I am curious what changes you've noticed in this in home address accessibility. Like I said, I've noticed some over the past 20 years, but do you see this changing and trending in any particular direction?
Yeah, and that's something I had looked at a couple of years ago too. I was just looking at certain records groups, but certainly we have seen more withholding of addresses, more laws that prevent release of home addresses, and in particular in the area of individuals, right? Rather than just saying home addresses are off limits, it's protecting certain groups and adding to the list beyond, in some places beyond judges, prosecutors, corrections officers, it's adding firefighters, it's adding anyone who has any sort of interaction with the public, where someone might maybe get mad at them and want to have some sort of retribution. So certainly we're seeing more closures, and we're seeing it in these very specific ways. Even in states that had sort of a protection for home addresses already, we're seeing them adding these individual exemptions, just so it's absolutely clear. And we don't want a judge or, a prosecutor to have their address released. The other thing we're seeing is, whereas we would typically see, public employees might have protected addresses either through cases like court cases or through the law, the new exemptions are for public employees from other records, right? So it's not your employment records, it's my property record where I can now scrub my address from this thing that would otherwise be public. Some of the states have this sort of complicated application process. It has to get renewed every year, but it's still available. Whereas me, the journalist, trying to see, did, the chief of the police pay their taxes, I may not be able to see that because either their name or their address could be scrubbed from that record.
Interesting. And building on that, Jody, I'll get to you, AJ, in a sec. We did have a question in the chat for you, Jody, and I think AJ, you chimed in. It's from Kirsten Mitchell, who's with the Office of Government Information Services, OGIS, formerly of Reporters Committee for Freedom of the Press, the New York Times, and the Sunshine of Government Initiative. So Kirsten, thanks for the question. We have these exceptions. Journalists always want exceptions, right? And so journalists can have this information. So Kirsten asks, how do they define journalist?
Yeah, and I'm actually interested to hear what AJ has to say if he's looked into this deeper, but on a surface level, what I saw was sort of not a definition of journalist, which made me a little happy because I hate to define like who's a journalist rather than what is journalism. But there were a couple places where it did sort of outline working at a, publication, a broadcast outlet, that sort of thing, but it didn't say who you are. And so not yet. It does concern me if we did start defining journalists in these laws, because it just concerns me. I'll stop there. But AJ, it sounded like, has looked into this a little deeper.
Yeah, I actually I did this last week. I looked through all the 50 state laws in DC to see references to journalist press and all the different exceptions. And one of them is access to public employees' personal information. But you see all these different references, and very rarely do they go beyond like a half of a sentence, right? There's some of them that define them very clearly, and they say that you have to you have to publish or so frequent or so frequently or stuff along that line, but very, very rare to go beyond just a mere mention. And I imagine it generally probably gets shaken out in common law. I did want to ask one quick question to Chip and the Southern Connecticut contingent. So we're all, I don't want to say we're absolutists when it comes to transparency, but I think we're probably most commonly interested in thinking how we can expand transparency. But you guys kind of walked into a kind of a different place, it feels like, where you're starting to think about it from maybe from a different direction. And I wondered if it was A, challenging, and B, changed any of your preconceptions about how you think about transparency. Not to assume that you had like shallow understandings of transparency prior, but to me, like when I arrive at stuff like that, I'm always, I don't know, it always makes me stop and think a little bit. And I just wondered, as you guys worked through these papers and wrote in depth about instances where maybe there should be less access, I just wondered how you guys approached that and how it felt.
Sure, I'll start. I certainly was uncomfortable coming into like a middle of the road point of view because I am a journalist and I do see the need for some of these records. But in our research, some of the examples of people being doxxed or threatened or harassed were journalists, right? And so that sort of put me in a place of maybe understanding it from the victim's point of view a little better, right? You're out there in the public, you're reporting, and someone disagrees with the thing that you've quoted someone else saying, and then they put your information out there and you're getting harassed, threatened, stalked, whatever it is. It's still, I see these very strong need for access to these records too. So, and that's where I kind of, and the three of us talked about it and fell down on it's sort of in the middle of, can we balance this need? Can we sort of have a test where the public's right to know outweighs this privacy interest and see it on a case by case basis, as much as I reluctantly say that because I know it adds delays.
And I hate to cut this discussion off because it's so good, and the eternal quest to balance privacy and access, we could go on for days, but we have to end, I'm afraid. And this has been so amazing. Thank you all for your great research, and thank you all attending for being involved, and hopefully this has been helpful and enlightening. So we'll go on to the next sessions and keep doing great work, folks.
Thank you very much.
Everybody.
Thanks, everyone.
Thank you all.
Hey, guys.